Thank you, counsel. Rebuttal, Mr. Rowley?
Thank you, Mr. Chief Justice. I think it's critical to remember that what we're dealing with here is an entry into the home, and there are these default constitutional rules that are decades and decades old. As the court has repeatedly said, at the very core of the amendment stands the right of a man to retreat into his home and there be free from unreasonable government intrusions. In Payton, the court said that the Fourth Amendment has drawn a firm line at the entrance to the house. And so these rules do not require, if you apply a probable cause standard, some kind of fundamental tweaking of Fourth Amendment jurisprudence. We think that they are a natural application of these basic Fourth Amendment principles. I would also stress that in a lot of these situations where the emergency aid exception arises, you have not just potential safety implications, but also criminal implications. Think of domestic violence situations or the situation that the officers faced here. And so having a parallel standard of probable cause to think a crime is being committed, but also probable cause to think that somebody is seriously injured or imminently threatened with such injury makes good sense. Conversely, if you adopted a standard that was a sliding scale, as the government has suggested, or a lower standard for the emergency aid exception, there is the potential for abuse. You could backdoor your way into a criminal investigation. I just note that while the state now has expressed concern about applying a probable cause standard, in its brief in opposition, it noted that a significant number of lower courts apply a probable cause standard, even, and they say it's functionally a probable cause standard, even if what they say in terms of the standard or the words used is different. And the court didn't suggest that that was a problem or that that stopped police officers and other first responders from going in and helping with an emergency. And so we don't think that applying a probable cause standard, which is the default standard, would prevent officers from stopping or intervening in an emergency. On the common law, because Justice Gorsuch asked about that, I just note that the cases that my friend features in the respondent's brief, best cases presumably, do say that the defendant or the potential tortfeasor has to be right. In Scott v. Wakeham, the court says, and I quote, "The question was not whether the defendant sincerely believed he was right, but whether he was so." So this reasonableness gloss is a restatement gloss. I think the more fundamental point, though, is that when you are asking about constable authority, the focus is what the rules that governed constable power and what they could do are the cognate rules. And the closest one is the affray rule. It actually applies to the same set of circumstances that were at issue in Fisher and in Brigham City. Both of those involved what I think the court called a melee or a fracas that is essentially an affray. And we know what the common law thought about that. What the common law thought was that the constable had to see or hear the affray if he wanted to break down doors and part the affray. That standard is fundamentally inconsistent with a standard below probable cause. The necessity defense and none of the other specific rules that the state and the United States outline supports a standard below probable cause. And so we think that the common law is more supportive of our position than theirs, and that it echoes not just the language in Brigham City, but it also underscores other exigent circumstances cases like Minnesota v. Olson, where the court has said that probable cause for an exigency is essentially the correct or the proper legal standard, and also in Santana, which involved an exigent circumstance, after all, hot pursuit, and the court applied a probable cause standard not just for the underlying crime, but to think that an exigency existed. The last thing I would say is that the United States says that reasonableness is an easier standard to understand than probable cause, but as Justice Jackson observed, probable cause is as settled a formulation as you're going to find in the Fourth Amendment. It's a standard that officers have applied, that the courts have developed over decades and decades. As the court said in Dunaway, the familiar threshold standard of probable cause for Fourth Amendment seizures provides the relative simplicity and clarity necessary to the implementation of a workable rule. A balancing test, particularly a sliding scale test, will not only be unfamiliar to first responders, but particularly unfamiliar to officers and other first responders.
Thank you, counsel. The case is submitted.
The Honorable Court is now adjourned until Monday, the 3rd of November.